Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. Both Jeff and I are certified appellate specialists. And as uncertified podcast hosts, we like to bring our audience of trial and appellate attorneys some news and insights that perhaps they can use in their practice. As always, we are most appreciative. If you find this podcast helpful, please send it along to a colleague.
Yeah, if you find it unhelpful, send it to your opposing counsel. Quick thank you to our podcast sponsor, CaseText. CaseText harnesses AI for the very best in legal research, document summaries, and document analysis. Imagine uploading a deposition transcript to the cloud and getting back a summary in minutes. Check out the latest CaseText product, CoCounsel, at casetext.com for more information. And see our show notes for a link to a discounted sign-up at casetext.com/CALB.
All right, and today we are pleased to welcome to the show Carl Cecere. He is an appellate lawyer who has practiced before the United States Supreme Court and many other circuit courts of appeals. Carl has written for the Harvard Journal of Law and Public Policy, SCOTUS blog, the Constitution Daily, the blog of the National Constitution Center. Carl is a member of the Legal Advisory Board for the Constitutional Sources Project, a nonpartisan, not-for-profit organization devoted to increasing understanding of United States constitutional history. Jeff, Carl, you may know, is on Appellate Twitter. That's one of the rarefied group of appellate attorneys who follow all sorts of things like the case that the new case about the Dormant Commerce Clause that you were looking at me funny because I had not heard about it and totally digested all the divergent views and doctrines of the Dormant Commerce Clause. But Carl Cecere is one such attorney who follows the winds and emerging trends of the United States Supreme Court and the various circuit courts of appeal. We thought it would be great to invite him on the show to talk about some about his practice, which sounds very interesting to me. Sometimes I'm just down doing the this grunt work on money cases. Jeff, you and I work on these money cases. We don't get to work on a lot of interesting public interest cases like Carl does. Carl also clerked for Mary Lou Robinson of the Northern District of Texas. I thought that's another point that we could discuss because Jeff, you and I sometimes get down in the dumps that we don't have clerkship experience. So we like to ask those with clerkships, why they think they're so much better than us.
Yes. Carl, hashtag clerk envy.
Yeah.
Yes.
Carl, welcome to the podcast. And why do you think you're better than we are?
Well, thank you so much, Tim, for that really kind introduction. And it's really great to be here. And yeah, we're definitely better. I mean, we've sat there with the judge. We've digested the coffee in the courtroom. We understand what GSA carpet feels like with no shoes on and those late nights preparing for trial. And that makes a huge difference in how we approach cases compared to mere mortals.
It's those little things, that perspective we will never have. Yeah,
that's right.
Judge's carpet under our toes.
The coolest thing about clerking, I gotta say, is especially in the older, like we were in a really old courthouse. It was a 1920s male, really big U.S. Postal Office that was converted into a courthouse. And they had these really cool old shelves, like the old lawyer bookcases with the glass partitions that covered the books and kept them from getting. Yeah, you pull it out. It was really cool. I just loved it. I just loved like looking up the things in the books and opening up the cases, and it was really neat.
New lawyers will ask you, what are books? What law?
Yeah, right. There were actual books at the time, and you actually read them. You pulled them out. You had a little stack of them beside you. But yeah, I do have to say, it really was a great experience being a clerk. I think, and I really wish I'd been able to do it at an appellate court level. I tried and I failed, so I'm kind of a mere mortal as well. But it really is cool, I think, to be at a judge's elbow and just work through actually deciding cases, because their perspective is a little bit different than a lawyer's. A lawyer's always trying to lob stuff at the court and wonder what's going to stick. And it's nice to be on the other end and be like, well, this is what convinced this particular judge of why we ought to go this particular way. And in a hard case, that's kind of an interesting, really insight. And I mean, it was also wonderful to get to know Judge Robinson, she was one of the first women judges in Texas. She joined the bench when she couldn't vote or own property. That's how long she had been on the bench
Oh, you're
in
kidding.
Texas.
Yeah, that gives
She's
you
a
some
Carter appointed to
perspective,
the
huh?
federal bench. Before that was a Texas appellate judge. And so she had just seen everything. She knew everybody in the, in the Texas legal community and had opinions on everything. And she was one of the most brilliant people I'd ever met. It was really cool just to get to know her and her staff and really get to spend some time doing that.
Yeah, did that I can't even imagine what kind of perspective that must have given her as a judge on on some of the basic principles of our judicial system and our our Republican form of government, equal rights and everything. When she's obviously reached a rarefied state where she's a federal judge, but at that time still could not vote or own property.
She wasn't a federal judge when she couldn't, but yeah, she joined the bench when she was 28, and yes, back when the laws in Texas were pretty backwards still. So yeah, she had a really wild perspective, and she was one of the most fearless people I've ever met because she had just busted through every barrier that was placed in front of her, and she had been practicing. When she was a lawyer, she practiced in front of virtually all male judges and with male co-counsel and male opponents. When she joined the bench, every one of the people who practiced in front of her was a man, and it was a whole it was a whole different scene. It was a whole different perspective for her to be able to assert herself in that environment, and she certainly did. So yeah, it was really cool.
Yeah, Mary Lou Robinson. Yeah, she'd be. I might have to do some of my own background research on her. That sounds like a just a very illuminating and inspiring person. She passed away in January of 2019. It sounds like a very very interesting clerkship. Well, let's make sure to bookmark that, and we'll touch on some of that experience. But Carl, would you tell us a little bit more about your practice, what kind of cases you take on, and don't leave out your experience in the U.S. Supreme Court?
So yeah, I mean, I'm in the division of appellate world, I kind of think of the pure appellate specialists and the appellate litigators, the ones who spend a lot of time in the trial court, kind of preserving issues and doing jury charges and stuff. And I'm probably more on the traditional realm. I don't spend a ton of time in trial courts. I'm mainly doing appeals, and I kind of do them all over. I do Texas state appeals. I've done appeals in other states. I've done a lot of work at the U.S. Circuit Courts, and I also do work at the U.S. Supreme Court.
You're based in Dallas, Texas, Carl, correct?
Yeah, I'm based in Dallas. That's right.
Yeah, and you're working in courts outside of Texas. Does that get nerve-wracking? Do you have to really go to school on all the local rules and local rules in the courts that you're working in?
It can be a little bit nerve-wracking, but I've actually found that we talked about Twitter. The Twitterverse is a really phenomenal resource when you're practicing in foreign jurisdictions, because you can always talk to pretty much any somebody who's practices regularly in that court whenever you find yourself in a new place. So it's pretty easy to avoid most of the pitfalls that wouldn't appear on the page.
No, it's interesting. Do you make use of Twitter as part of your normal course? If you're practicing in a new state and you put out an APB on Twitter, do you use hashtag appellate Twitter, or what? How do you go about it?
Well, I mean, I've gotten a pretty good sense of where people are located just by talking to people over the years. So I usually know, if I'm in Nevada, I know who to talk to, and if I'm in Arizona, I know who to talk to. And if I'm in some completely random jurisdiction, if I'm in Alaska, I might throw out an APB to people. But otherwise, I kind of have a sense of who I know and who I trust in those different places. Yeah. And it makes a huge difference to have like a human touch in a different place. And I've also brought people on as co-counsel or local counsel in different cases as well, and that it can be a great resource for that. And that's one of the reasons I can bring my practice so easily outside of Texas, is that I can meet a lawyer in New York or in DC or in Oregon in minutes, and we can be talking about a case just off the bat. And I can just be sitting on my duff in Dallas eating some barbecue, and it's best of all worlds that way.
Yeah. All right. Well, I interrupted you. Tell us about some of the cases that you're working on, or cases you have worked on. Some formative experiences or war stories, maybe.
So, well, one of the cases I'm working on that's really interesting right now is the Purdue bankruptcy case, and Purdue is the producer of OxyContin,
Right.
and one of the real driving forces behind the opioid addiction in the United States, and as it turns out, in other places in the world as well. So I actually represent a group of Canadian municipalities and First Nations, which are the equivalent of native tribes in the United States, that are challenging the American bankruptcy of Purdue. And one of the reasons the case is interesting is not only because of the gigantic size of the harm that Purdue did, but also because, one of the real trends right now in big mass torts cases is to try and use the bankruptcy laws to shield people who don't go into bankruptcy. And that's been a big battle we've been fighting in a number of different jurisdictions, and we're definitely doing that in Purdue, because Purdue is owned by the Sackler family. Purdue is a name they just purchased from somebody else when they bought the company. And the Sackler family tried to insert something in their bankruptcy plan, in the Purdue bankruptcy plan, that would shield them from any liability from anyone ever asserting a claim against them for opioid-related harms, even though the Sackler family made all of the decisions.
Which is normally fine in bankruptcy when you have a debtor who's fully disclosing and is subject to the bankruptcy rules, but to have somebody who's essentially a stranger to the process. Tim, you and I covered in this podcast an appeal involving a settlement that ultimately was rejected. Carl, are you involved in that litigation in terms of a settlement that was rejected and then was bouncing back and forth between the Court of Appeal and the bankruptcy court, or am I confusing cases?
We have not been offered, nor have we been able to have an opportunity for a settlement in in Purdue. The state claimants in the case settled during the course of our appeal, but now the only appellants or appellees, we won in the district court, so Purdue is now pursuing this on appeal in the Second Circuit. The only appellees in the case are us and the U.S. trustee. But we have not had the opportunity to settle. It'd be great if we did. But that's part of the problem too, is that you're right. Sometimes complete strangers to the bankruptcy are given some kind of protection because they don't want people to interrupt the process of distributing funds and things like that. But the Sacklers are unique in that they basically drove this company into bankruptcy. They shipped a bunch of the assets from Purdue offshore into accounts in the Canary Islands, which I don't know where that is, but basically beyond the reach of any creditor, and then just sort of said, well, here's what you're left with, and we want immunity for this as well. So it's a really, really strange and unique set of circumstances. We think really an abuse of the bankruptcy process, and it's kind of a piece of cases that are going on around the country. If you've been following it at all, Johnson & Johnson tried to spin off a unit and bring it into bankruptcy so that which is one of the biggest and most solvent, long-standing companies in the world, could stay outside of bankruptcy, but then shed its liability for talc products into bankruptcy and then kind of cabin those losses. And then you see in 3M with they've tried to use a bankruptcy stay to prevent litigation against them over there.
This is the trend that you referred to of large companies trying to use the bankruptcy protections as a shield for liability. Now, in following this trend, do you follow bankruptcy law? Is this one of your areas of practice, or are you able to just come up to speed when you got involved in this case?
I've been lucky enough to just experience a number of bankruptcy related appeals over time. So I was able to jump into Purdue pretty well. And it is not an area of the law you want to approach kind of randomly, because there's so much procedure to understand. And, it's kind of like there's a bankruptcy overlay for every element that you'd have in a normal appeal. In fact, there are even bankruptcy specific mootness doctrines that aren't even really mootness at all, but they kind of float around. And there's also kind of an attitude amongst the courts of appeals that they don't love to touch bankruptcy cases because of their complexity. They're always kind of afraid of doing something wrong. So bankruptcy law has kind of been allowed to develop without a lot of oversight from the appellate courts and even from Supreme Court. So there's a lot of things that you do in bankruptcy law, and it's like you read the code, and you're like, that's not really in the code. And then the bankruptcy lawyers will just tell you, well, that's just how we do it. I'm like, but it's not really in the bankruptcy code. They'll be like, yeah, it's fine. I'm like, I don't know. With the new Supreme Court majority, we're going to go back to reading the code a lot more than we used to. And I actually think that's going to be a good thing. Although I think it'll probably, in things like this, third-party releases or bankruptcy spinoffs, it's probably going to lead some reforms of the bankruptcy code when the court actually does approach these things, because it really has drifted a little bit away from the text.
Yeah, bankruptcy courts are where the equitable powers of a court seem to have their greatest influence, more so than civil or family or probate. Equity in terms of the debtor and their creditors and settlement. And it's like the Wild West. Tim, I don't know if you've been involved in family law appeals, but it's kind of like the Wild West in terms of judges making rulings here and there. And I do concur that it is time for the pendulum to swing back a little bit.
Yeah, I really do hope it will happen. And I really hope that the court, we'll see. There's a decent chance that the Purdue case ends up before the Supreme Court one way or the other, depending upon how it comes out. And, I would assume J&J is trying to do their shenanigans again. So it'd be nice if one of these cases that are going around right now ended up in the courts. The court could kind of say, yeah, we're going to read the code a little bit differently than we have in the past. And they'll get that message, I think.
Yeah. Now, Carl, how do you get brought into these kinds of cases involving national significance, involving players with pockets billions of dollars deep? These are waters that a lot of us would like to splash in from time to time, but it's high profile cases, and sometimes other public interest firms, whether they're high profile or not, sometimes there is some ambiguity about how the attorney is supposed to get his payday.
Yeah, I think it really helps me a lot that I'm a solo, and if a case that comes in that's a little strange, I can have a meeting of the partners and come to a decision really quickly about whether or not to take something that a lot of other people might not touch. So I think the basic flexibility comes from there. And it's allowed me to do a lot of things that I wouldn't have been able to do in a different environment. I think, but
on the other side of that coin, when you're the solo, sometimes you don't get approached by the billion-dollar companies or by the cases that have hundreds of millions at stake.
That is true. It can be kind of a tricky bit to get in front of people and to kind of establish your bona fides when you don't have a name that people recognize. But what I do a lot of the time, it's kind of my basic practice development tip is I travel a lot. I go to where the cases are. I sit in a great jurisdiction for appellate work. There are some of the best appellate lawyers in the world are right here in Texas. And we've got a really well developed appellate bar. So that we have that, and that I can take advantage of that. But in developing the practice the way I wanted it to, since I kind of had a stable base to build on, I was like, well, let's go get some other cases. And what I've always done is I've just spent, several weeks a year in New York or in DC or in LA, just getting to know lawyers and getting them to know that I'm out there. And again, part of that is from people I meet on Twitter. People approach Twitter in different ways, but to me, it's been a phenomenal practice development tool. Because I meet people on Twitter and then I go meet them in real life. And then, from there, it's pretty easy to start working on cases together.
That's interesting. So that's kind of a nice hybrid of the classical way of networking and the new technological way of networking is you don't just live on Twitter sending tweets out and having a whole bunch of networking friends that you've never met before. You actually go out and attend? Do you seek out large legal conferences? How do you make a point to meet the people that you meet online?
Kind of all of the above. There are some conferences I really like to go to every year. And I've, after you go a few times, you kind of know a few people, and you find out the ways to meet the right people. But part of what I like to do is I really like to go and just spend a week in a town and just go and meet whomever I can. I mean, people my level, people who are more senior to me, people who might have work, people at organizations or trade associations that, might send me a little bit of work. I'll just do it for a week, just nonstop. I mean, an ideal day is to go breakfast, coffee, lunch, coffee, dinner, drinks, with different people, and just meet as many people as I can. And I'm not super targeted about how I do it. I just kind of meet whomever's interesting. And, if I like what their practice is about, and we figure out ways we can collaborate. And, it doesn't often happen, but frequently happens that some really cool cases come out of those meetings. Yeah.
Now you came from the world of BigLaw, and now you're a solo. Do you still draw on the context and on the context and cachet, I might say, from your time working in BigLaw?
I was really blessed with the opportunity to work at Aiken Gump at a really awesome time in Aiken Gump's development, because they had just hired Tom Goldstein, who he runs SCOTUS blog. He recently retired from the practice of Supreme Court law, but he was amazing, and he was also extremely democratic. He was really willing and able, and offered to work with everybody in the firm who wanted to work on Supreme Court cases, and I bugged him weekly to work on things. So he gave me several cases. In fact, one of the cases that I got to work on, my first Supreme Court case was Heller.
Wow.
So I'm on the counsel to the District of Columbia in Heller. So I got my feet wet really fast, and my relationship with Tom and the people at Tom's firm have continued ever since then. And that was my foothold into Supreme Court practice. So from Tom, I met a lot of other people. He introduced me to people. He got me in on cases that got me involved in the plaintiffs' bars and the securities bars all over the country. So just from Tom and Tom's wife and Kevin Russell, who was his partner, and his wife is Amy Howe, just meeting them has just been open doors all over the place. And I frequently still get calls from people at Aiken Gump when, they don't have their own appellate department in Dallas. So I get calls on appeals from them quite often, and it's been a tremendous resource. And it's great, and I tell people who go to Aiken, who go to big firms, that they should really invest in the community of people that they have there, not only while they're there, but because when they leave, a community that doesn't go away. If you leave on good terms with people and you keep up with them, it can be really a huge resource for you for forever.
Have you spotted any trends in the world and culture of BigLaw in the last few years? Have things changed as compared to the time when you were at Aiken Gump?
I think the practice of law is completely transformed from the time I was practicing in BigLaw.
How long ago was that?
So I think I left in like 2011, 2012.
Okay, so we're talking about last 10 years. You think there's been a seismic change in BigLaw, huh?
Seismic shift. I think not just one. I think that you could look at several different ones. We had libraries. We had
like, do they convert all the libraries now into work stalls?
Yeah, and I actually went to, Aiken Gump moved offices and didn't bring their library with them, and they didn't bring their files with them. So now they have these like really random collaborative spaces in the middle of the hallways, because they don't quite know what to put in the place where you would put those sorts of things.
Think about Chat GPT portals.
Yeah, but I think that was a big shift, was that, number one, just the move to a paperless office was a huge change, and not doing huge document reviews as kind of like the basis of an associate's life. That's a big change. I think, I think now we're experiencing a lot of opportunities to compete against BigLaw because it's gotten so expensive. You're talking about for an average partner at a law firm to be billing $2,000 an hour, not even like the best in their field, just like a guy. That's pretty easy to compete with on a numbers basis if you're pretty good. And so it's created a lot of room, I think, to grow underneath the BigLaw model and to say, well, you probably don't need that guy who's going to cost like twice, 3 times, 4 times as much as me. And I'll do as good a job, if not better. And that's been another thing that's been really great about Twitter is that, I put my briefs up there and people will talk about them, and I've gained a reputation as a good writer and as a good advocate through that. And so I've got a pretty decent reputation around the country that when I meet with people, they're like, oh yeah, you're Carl. You're not some random name. You're a known quantity and you're associated with quality, which I think is really cool. And that was surprising. That was not what I intended to do, but it turned out to be really great.
Let's talk about brief writing for a second. As part of my extensive due diligence to prepare for today's interview, I went back 2 days on Twitter, and I love this post. You say the main character of your opening brief should be the court below, and the main character of your reply brief should be your opponent. It's fantastic. Can you expand on that?
Well, as you can tell, for one thing, I mostly represent appellants.
Yeah.
That's usually where the ones that hire the lawyer outside the firm. When they won and everybody's happy, then they'll usually take care of it themselves. But that's part of it. And I really do believe that. I really do believe that you really should engage with if you're lucky enough to have an opinion that you are appealing, and not just some generic court order that doesn't describe the reasons why. That's hard for me to engage with because, you want to say not only why you're right, but you want to put it in a context of like, I'm considering the arguments against my position. I'm considering what the trial court said. And I'm not trying to paint the trial court as a bad guy. I'm just trying to say this is what led the trial court to make its decision rejecting us, and I just don't think that that's right. I think that's a really important thing to do. I think that's sometimes something that a lot of appellate lawyers are reluctant to do. They don't want to seem mean or not nice to the trial court, so they try to pretend that the trial court's decision never really happened. And it makes for this very abstract and hard to follow legal brief. You want to talk about what people did and what they said and why they said it and why what they said wasn't the right thing, and not just kind of float around above it, trying not to create any kind of controversy. And then, that shifts when you have a brief from the other side, right? Because you have what the trial court did, you deal with that, you say that what they did. And then the appellee's reaction to what you did is really important. I mean, did they fall back from what the trial court did? That's significant if they're not willing to fully defend exactly what the trial court said. Are they expanding upon it? Are they finding a reason to dance around what the trial court did? And I'm going to make sure to point that out every time and really push them on that and say, and then, the things that they don't address in my brief, I'm going to say, have they conceded that? I mean, they don't contest that this happened. So it sort of fills out, and it's sort of like every time they cede ground, I want to make sure that I cover the ground that they've ceded, and I want to tell them what to do. And again, it's not really to make them the bad guy. I mean, I guess the opposing counsel is kind of the bad guy, but I don't try and make them seem stupid. I just try to say they're not fighting me here, so they're sort of conceding this, and
you're keeping score.
They're wrong here, and they're not even comfortable defending what the trial court did. Whenever you're in a federal district court, and those district court's opinions are going to be, put into the federal into the federal supplement, they're kind of the law. So the Court of Appeals doesn't want the bad law to be sitting out there. And then when you go to the next level, whenever you're in front of a Supreme Court, whether it's a state Supreme Court or the U.S. Supreme Court, they don't want bad law out there on the books. So when the other side won't defend what the trial court did, you're almost 60-70% of the way to the reversal, right? And it's like
Huh.
they won't defend it. They're trying to create some new rationale. It's like, well, that means the law in the books is not right, and that's a problem.
Yeah.
Interesting. So if the main character of the opening brief is the court below, the main character of your reply brief is your opponent, when you represent the winner, the appellee, or in California, the respondent, is the main character the deferential standard of review?
I mean, I would probably still make it the lower court. I would still probably say, oh, that judge was so good and he was so smart and he
He's the
really
hero,
knew
not the
this really
villain.
well. He did a great job, man. And he did
Okay.
and everything that nasty appellant is saying about those guys it's just not fair, and it's not justified, and it's not supported. It's like that's what I like to do. I definitely like to lean on the standard review to the extent I can as well. But I mean, to me, brief writing is always about storytelling. So it's about what real people do in the real world, and it's not about abstract principles of whatever.
Have you used any of the products that are coming out there in terms of AI? It's just like Clear Brief and I think TypeLaw is another to help you with brief writing.
I have not really gotten into that yet. I've played around a little with ChatGPT enough to know that it's going to be a really powerful tool, but maybe not yet. But I do think that AI is going to make a big difference, especially for small firm lawyers, and especially for lawyers who work on the plaintiff side, because it's going to be a real challenge to the billable hour at the end of the day. And so the BigLaw model, which is built on billing a ton of hours on every little thing, well, I think that AI is showing a great capability to do a lot of what a junior associate once did, and that means that a solo can level up, and that a BigLaw firm is going to be real top heavy in their billing. And a plaintiff, when you don't necessarily have to tie yourself to the billable hour like me, I do a mix of billable work and contingency work. I mean, it's a real advantage to be able to play against people who are spending hundreds and hundreds of hours doing the same thing that you're doing for a lot less money, and time.
Interesting.
Yeah, Carl, I had one other question before we move completely off the topic of brief writing, and you mentioned about I think we had just segged into advocacy in the Supreme Court, whether it's a federal Supreme Court or a state Supreme Court. These are courts of last resort, and really they're not courts of error in the sense that they don't care about the parties, right? They only care about making sure that that the precedent in that jurisdiction is uniform, and it espouses the doctrine that that particular Supreme Court prefers. And so I wondered if the brief writing and approach to advocacy changes in your view when you are appearing in front of a Supreme Court, which is not a court of error, because again, does the storytelling change? Because again, the Supreme Court, you can't count on the Supreme Court caring if a particular plaintiff was aggrieved. For example, if you're in a neighbor dispute, a tree view dispute or something, the Supreme Court's not there to tell you whether you have a right to a tree. It's only there to tell you whether 330 million people across the country have a right to a tree. So it's a different kind of a focus of inquiry.
I think it's definitely a different. Excuse me. I think it's definitely a different mindset that you have to approach these kind of cases with when you're in front of the Supreme Court or any state court of last resort. Because of that, you're right. You have to approach it from, let's talk about what the law is, and let's talk about whether it's right or it's headed in the right direction. I mean, the law becomes more of a character rather than like a prop, that you apply and put here. This is the law. When you're in front of those course of discretionary review, you got to do a lot more of that. But at the same time, I think it's a little bit overplayed to say that they don't care about the facts. I mean, they're still human beings, and there's no secret in the Supreme Court bar that if they're going to, if an advocacy organization wants to present an issue to the court, they're going to find a case with sympathetic facts. They're not going to just take some random case where the court's going to be like, well, I just don't really care if they win or lose. They try to push the justices' emotional buttons because they have emotional buttons that still can be pushed. And so I think that's kind of an overlooked element of that level of advocacy, is you do need to think about not insulting them by focusing too much on the facts, because like, this just is error correction. You got to present it to them in a way that isn't just error correction, but you also need to present it with a human face and a human touch and say real people are being affected by this. I think it creates a lot of new opportunities for advocacy, but it also kind of narrows the range of advocacy that you can have, because especially at the U.S. Supreme Court, you got 9 people who have a very set map that they apply to the law. You know, their views on a lot of things are fixed, and not in a closed-minded way. They've seen issues like this, you know, in one way or the another. They touch 8,000 petitions a year and decide whether to take a case. They know what they're interested in. They know what they're not interested in. They know what their view of the law is in any number of different areas. And so you have to accommodate that. And some of the justices are just not going to be winnable on your issue sometimes. Yeah. You know, you'll know that, well, Justice Gorsuch is not a get on this case. You know, maybe Justice Kavanaugh is a get, but not Justice Gorsuch. He's written on it. He's talked about it. You know, you just know he's closed. So you're searching for a kind of a different thing than you are in an appellate panel. In the panel panel, you don't even know who you're going to get. You don't know what is going to happen. But with the Supreme Court, you got 9 people. You know exactly where you're going to get, and you have only limited shots to shoot with them. And you're like, well, there may be these 2 or 3 avenues to a win. But you got to go through 9 people's very fixed views.
Yeah.
So in a way, it's a lot more fun to be at the Court of Appeals level because the opportunities for advocacy are kind of broader.
Yeah.
You have to be a lot more focused when you're at the Supreme Court.
Yeah, and speaking of that, the fact that most of us attorneys, and especially those who pay attention, can get a pretty good sense of whether they can count the votes on their case in the U.S. Supreme Court. And maybe that would be a segue to a question I wanted to ask you about. Judge Sutton of the Fifth Circuit has said that litigants should consider directing their constitutional challenges in state courts using state constitutional provisions, suggesting that there may be more play in the joints. And you might not know that maybe they use similar language as used in the federal Constitution, but the Supreme Court of that state is at liberty to interpret it differently than has the United States Supreme Court. Or Judge Sutton is a federal judge, and the feds are always trying to find a way to get us to file in state court instead of federal court. So you could take that cynical view as well.
Well, I think Judge Sutton's right. I think he wrote a whole book on state constitutions.
Yeah, 50 Imperfect Solutions, I think it was called.
Yeah, and it seems like there are a lot of the state tradition of drafting constitutions. They seem like they borrowed a lot from each other, so you can learn a little bit about the law in one state and apply it to the state constitutions in another state. And I think he's totally right. A lot of for example, I don't want to take a controversial topic just because, but it's useful. In the abortion context, even if Dobbs settles a certain question on the federal level, there are a lot of protections under state constitutions that might be interpreted to cover the same issue. There are a lot of constitutions that explicitly protect a right of privacy, in one form or another. And so you're really free to make a lot of arguments about abortion that are now foreclosed in the federal court, and you can do in the state court. You can also pass a law in the state court, that's going to apply in the state court a lot easier than you're going to get anything through Congress. So you can also inform, you can also change the law you're applying. That's a big deal. And we had a case that I thought really illustrated the distinction really well. I was involved in a case early in my career where we were challenging the state funding mechanism for funding public schools. And there are a lot of state constitutions that protect the right of a public education as a constitutional right under the state constitution. And so the law in the state courts has gone a completely different direction than the federal courts, because the federal court said you just can't say that you're denied a right of equal protection under the federal constitution just because your poor school district gets way less money than the rich school district. But you can under the state constitutions, because the state constitutions provide a baseline right. It's not just a kind of an abstract sense of equality. It is, you have a right to an adequate education under the state constitution, and that changes a great deal about how you litigate those kinds of cases. And there's a whole body of case law that talks about how the federal and state approaches diverge.
Yeah. And I misspoke a moment ago. Chief Judge Jeffrey Sutton is Chief Judge of the 6th District.
I didn't want to step on you, but yeah.
Thank you. All right. Well, let's Jeff, should we talk about oral argument and briefing tips, or do you want to talk about the Sokalow case?
Yeah.
Guest choice, Carl.
Well, good question.
Yeah, you've got this case in the Second Circuit arising out of the PLO's support of terrorism in the Sokalow case. I wonder if you maybe give our audience a little bit of a primer on that.
So I don't represent the parties in this case. I've just written a series of amicus briefs. And it's just one area of focus that I have developed is anti-terrorism cases, civil cases against sponsors of terror, banks, PLO, Iran. I've done a number of different cases involving those kinds of issues. It's just something that I find interesting. It compels me. I really like the people who tend to be involved in those cases. So I've got to know a lot of them.
The attorneys, I assume you mean.
Yeah, the attorney, well, and the clients. I mean, I've got to know some of the people personally involved in these things.
Yeah, what is this case about? I wasn't aware of the Sokalow case until I was reading up on your work.
So the Sokalow case has been a really interesting case that's been going on. There's always been a challenge in getting jurisdiction over foreign sponsors of terror in United States courts. In particular, the PLO, the Palestine Liberation Organization, and the PA, the Palestinian Authority, which governs Palestine. It's really hard to bring them into court because they don't fit necessarily in all the boxes. They don't necessarily fit under the FISA, the Foreign Sovereign Immunities Act. And so it's kind of a challenge to get jurisdiction over them. And then as the Supreme Court got more interested in and kind of curtailed the options for personal jurisdiction, it's become a real challenge to get these people in court. So the Sokalow case arises from a kind of back and forth that's been going on between the Supreme Court, the Second Circuit, and Congress about how to deal with this problem. It used to be that getting a jurisdiction over the Palestinian Authority was fine under very loose doctrines of personal jurisdiction, the old international shoe kind of framework applied to foreign sovereigns. Huh. But then when the Supreme Court started clamping down on personal jurisdiction, that became none available. So the Second Circuit started dismissing cases against the Palestinian Authority. And we've got a couple of different ones involved. Congress responded by passing something called the Anti-Terrorism Clarification Act. This was back in 2018, that made it possible to get jurisdiction over the PLO and the PA if they either, number one, continue to sponsor acts of terrorism or give payments to terror sponsors, because the PA pays people martyrs benefits and things like that, or people who are in jail for committing acts of terrorism. Sometimes they get money. So we said cease doing that if you want to avoid jurisdiction, or cease contacts in the state of New York. And where the PLO, where the PA has a diplomatic mission at the UN.
So this was, just so I understand, the personal jurisdiction question, or the scope of personal jurisdiction was expanded by congressional legislation.
Yeah, they passed it. They couldn't change the constitutional limitations of personal jurisdiction under specific or general jurisdiction. But what they did was they moved into jurisdiction by consent. They said basically, if you're going to continue to do things, you'll be have deemed to have consented to jurisdiction in the United States.
Oh, interesting.
So
So the legislation created a presumption of consent.
Yes, and said, you know, if you're going to come to New York and you're going to raise money in New York and you're going to do a bunch of fundraisers there and you're going to have offices there, then you're going to be deemed to have consented jurisdiction.
That seems like an interesting. I don't mean this as a pejorative when I say end run around, but a pejorative way to solve that issue. A clever way to solve that issue of the limits of personal jurisdiction and to make a statutory presumption of consent to the jurisdiction of the court. So how is that playing out? Is that part of what's at issue in the Sokalow case?
Yeah, well, they rejected the initial version of that statute. That was the initial. So the Second Circuit said the ATCA was ineffective for some very creative reasons. So then Congress went back and created a new law, and it's called the Promoting Security and Justice for Victims of Terrorism Act, and that was 2019. And that was actually passed the first time we took the Sokalow case to the Supreme Court, because we appealed the dismissal of our case from the Second Circuit to the Supreme Court. And during that time, Senator Grassley, who's my client, he passed the PSJVTA that kind of, and it's very technical about exactly why it didn't work, but kind of passed that act to overcome the Second Circuit's objections. We went back to the Second Circuit, and the Second Circuit rejected us again, saying that you can't create conditions for personal jurisdiction and manufacture deemed consent, although we do it in other kinds of circumstances. And that's where we are now. Is I think we're at rehearing at the Second Circuit. No, actually, I'm sorry. It was at the district court level in Sokalow. They said that the PSJVTA didn't work the way it was supposed to. It was unconstitutional. Now we're at the Second Circuit. We're going to try and win there, and then we'll probably be headed back to the Supreme Court again.
How did you come to represent Chuck Grassley?
Well, I mean, it's another Twitter connection. John Elwood is a big Supreme Court lawyer, and I've met him through Twitter, and he recommended me to the people who were working on that case. They had seen that I'd done some anti-terrorism work, and then recommended me to represent them in this amicus group. And then so we represent about 20 or 30 lawmakers, depending upon the particular jurisdiction, the particular brief. And they've filed a bunch of different briefs in these kinds of cases, because there's a parallel series of cases that are going on all over the place in the DC Circuit and in the Second Circuit as well. This has been really interesting.
Well, I think maybe to close us out, I wonder if you have any predictions for the rest of this Supreme Court term. I know a few months back you had written a Supreme Court preview of the term, and so now we're through much of it. But I wonder if you have any predictions for the fireworks that are in store for us at the end of the term.
Well, I mean, I think that most of the politically charged cases coming from this term, we kind of know the outcome of. But I think the real story of the Supreme Court right now is the slowness of its pace of decisions. There are something like, I want to say 70 cases outstanding that don't have opinions yet. And that's way out of line when you're considering that in the next 2 months, the court's going to go on recess and have decided all of those cases. That's just a huge workload backlog that's gone on. That's really unprecedented with the court. And I mean, it's got me wondering whether or not there's a kind of personal fallout between the justices over the Dobbs leak, the leak of the Dobbs opinion. And whether that's affected their ability to circulate drafts and feel comfortable sending things to each other, or whether something's going to end up on the news. I don't know if that's, I don't really know if that's the case. And I really hope that's not the case. I'm hoping it's just some kind of other factor. It could be that the shadow docket, which is the kind of supreme pre-merits briefing, has become much more extensive, and there have been a lot of emergency applications. It could be that, could be those kinds of distractions. But I do worry that the Dobbs leak kind of affected the interpersonal relationships of the justices and their trust. That's kind of integral for their decision-making process.
You mentioned the shadow docket, and I was hoping to I see that later this month, in May 2023, there's going to be a book released by I think a university of Austin, Professor Stephen Vladek, The Shadow Docket: How the Supreme Court Uses Stealth Rulings to Amass Power and Undermine the Republic. I know that there's been a lot of talk about that, anticipation of what that's going to talk about. I don't know if you have any opinions on the Shadow Docket and how that's been used.
Well, first of all, everybody should buy Steve's book. Steve Vladek is he's a professor at UT, and he's a phenomenal Supreme Court scholar, and he's actually also an advocate before the court on a number of occasions. He's a national security expert, so he does a lot of cases involving servicemen, and he raises really interesting points about the problems with doing cases on the shadow docket. I tend to concur that like it's becoming a problem because there have been a lot of cases, with the changes in the judiciary over the past few years, where you have a lot of very aggressive judges certainly on the conservative side, but also the liberal side too, who are really willing to, take a ruling and declare an entire, agency unconstitutional or overturn portions of the Obamacare, the Affordable Care Act in a single swoop. Or overturn executive actions as they come up, like the student loans or the Muslim ban when it was happening under Trump. That's pushing a lot of work to an area of the Supreme Court's docket that it's not really well equipped to handle, because you try and get an emergency stay, and that stay is often determinative of the merits of the case, because one of the elements you've got to establish is a likelihood of succeeding on the merits to obtain the stay.
Right.
So that single determination, which is just one factor in one element in the stay application, which is often written over a weekend, that becomes essentially the only opportunity the advocates really have to present their case to the court in what would otherwise be something that would take a process of months, involve lots of amici weighing in and giving their views, and really taking the opportunity to really make a deliberative decision. Now you're doing these things really fast in weeks, with a tremendous time pressure that really aren't getting the best product out. So I don't think it's really great. I don't think it's entirely the Supreme Court's fault, because a lot of it is really related to changes in the judiciary and the kinds of aggressiveness that they're willing to issue in nationwide injunctions. But I do think the Supreme Court's going to have to respond in some way and say, well, we're not going to, maybe we're not going to make merits determinations at this stage. Maybe we'll just stay the litigation, and then, let it go to the merits, but not really weigh in so heavily at the shadow docket stage. It really is becoming a shadow docket. It's not conducted in the full view of the public.
Yeah. Well, yeah, very interesting. I think there's a lot of topics we could continue to explore, but I did want to point out that you pronounce it amici. Is that the way? Is that the proper pronunciation?
I've heard it a billion different ways, and I don't think there's any standard definition. I picked the one that I think is the least weird of all.
Right.
Amici, amicus. Amicus is one that you can say, but I just find it really unnatural.
Amicus? Is that a thing?
There's in many different ways of saying amicus as there are people saying it.
Yeah. And
none of them actually pertain to the original Latin, I'm told, and
Yeah.
I don't even know what that actually is. So.
Well, no, I like how you put it. It sounds least weird to me. It's one of my own personal maxims about writing is that if it sounds weird, then it's not English.
Yeah, I mean, I feel like my general approach to briefing and arguing in front of judges is I want to create as little friction as possible, because
that's right.
I know that the process of reading briefing and making decisions is not a pleasant one. It's not. Between my brief and a nice juicy novel, they're not going to pick mine up just for fun. So I really try and not irritate them. I try and irritate them as little as possible,
Well,
and help them get through it as easily as they can.
On that note, Jeff has a few closing questions for you about how to make your writing the least conspicuous, least unintentionally conspicuous.
Great.
All right, Carl. This is the time for our patented copyrighted segment of the show that answers the most pressing questions that vex appellate nerds around the world. The dreaded lightning round. Short responses are required. One sentence, one word. Let's see how many of these we can get through. Font preference: Century Schoolbook, Garamond, or something else?
Century BT.
Century BT?
Not Century, not
Okay.
Century Schoolbook. Yeah.
All right. After a period, do you do one space or you do something
One space.
incorrect? Okay, fantastic. Or pleaded when writing in a brief.
Pleaded.
All right. Headings, let's put the Supreme Court aside. When you're in those other courts. When you're in a brief, your major argument headings, all caps, initial caps, or sentence case?
Sentence case.
Fantastic. Left justify, again, ignoring the Supreme Court. Left justify or full justify?
Full justify, but I appreciate the other way as well.
All right. Tim, did I hit them all, or was there one you had a pet peeve on there?
Oh,
Garamond. I hate Garamond.
Wow.
You just had to get
Strong
that last
coffee.
dig in
Just
there.
had to get that in there.
Garamond.
It's just the absolute worst. Now, and I have to say it because I read a brief. I had to respond to a brief that was under page limits, and it was 12-point Garamond and 10-point Garamond footnotes. 10-point Garamond footnotes cannot be read without a magnifying glass because it's like this teeny tiny little thin font, you know.
Jason and I were putting a motion together to file the State Court of Appeal, and we had a co-counsel, Fran Campbell, and Fran edited it
Nice.
to include Garamond. And Jason, my paralegal, comes to my office and he says, "Jeff, do we have to file this with Garamond?" I said, "You do what Fran says." So, Fran, if you're listening to this podcast,
I think you're going to have to put that in your retainer. The deal breaker.
Yeah.
All right, Carl.
You should ask one other question, by the way.
What's that?
Word or word perfect, and the answer is word. And I have a real beef about that too, because once I had a Fifth Circuit emergency motions deadline of like 4:00, and I received something in word perfect at 3:30, and they're like, "Just flip it and file it." And I was like, "I don't have word perfect for my machine," so I had to I'm searching around the law firm trying to find a computer that has word perfect on it, and it created panic that makes me hate word perfect to this day.
I wasn't even aware WordPerfect was still a thing.
Yeah.
I guess here it is. Yeah, they still
since
got a
law
website
school.
and everything.
Yeah.
All right. Well,
I mean,
Carl, congratulations. Not only did you survive the dreaded lightning round, I think you exceeded it and added a new question. I guess we need to start putting word perfect into the rotation.
Right. And how do you feel about Garamond?
Yeah, I think we've established that, and I prefer you didn't say it again because I might have a little PTSD about it.
Right. All right. Well, that's going to wrap up this episode. We want to thank, again, Carl Cecere for joining us. And we also want to thank, again, our sponsor, Case Text, for sponsoring the podcast. Each week, when we include links to the cases we discuss, we use Case Text for those links. And listeners of the podcast can find a 25% discount available to them for the classic version of Case Text if they sign up at casetext.com/CALP. That's casetext.com/CALP.
Yep. And if you have suggestions for future episodes, or if you have a complaint, put complaints in Garamond and in WordPerfect format and send them to info@calpodcast.com. And in our upcoming episode, look for tips on how to lay the groundwork for an appeal when preparing for trial.
All right. See you next time.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.